We going from the top?
From the top.
From the top. So our big announcement for today are our social media influencers and Best Pet Award, which actually these pets we don't even know the names of. So we're going to have to get the names sent back in. But the winner is actually Debby Farrow for the $50 gift card to Target and a swag bag. We got lots of great entries, lots of great comments. But Debby won based on social media influencers and the tiebreaker. But we definitely need to know the names of the dogs so that we can put them up there. So please, Debby, reach back out.
Beautiful dogs.
Today, though, we're actually going to be talking about trademarks. A wonderful topic that my partner here, Elizabeth, is actually very knowledgeable on. Beth, welcome to the show.
It's an honor to be here, always.
Isn't it? Yes. I thought so, too. So, I think businesses wonder what a trademark is.
Right.
Let's start at the basics. I mean, what is a trademark?
So a trademark is a legal protection that you get for your name, your logo, your tagline, and it gives you the right to use that exclusively in association with your services or goods. I guess we'll start there. This protection, intellectual property protection you would get for goods or service. Other things like patents, which are inventions, that's different. Copyrights, which are artistic expressions, that's different. But trademarks are associated with what you use to engage with your clients or customers for the sale of goods or services.
Yeah, I represent a lot of businesses and business clients. I think that a lot of the time they don't think about the trademark and what the risk is.
Right.
The risk is that somebody else opens a business and tries to take your brand.
Or somebody else already has that business.
Or they already have that business. What happens if somebody already has the business?
Well, you often get a what we like to call a nastygram, a cease and desist. And
Drafted.
Yes.
Drafted.
So if you've put a lot of money and effort and marketing into a particular name or logo or tagline, you're faced with a situation where you might have to start over.
Which people don't always think about the expense and the cost. I mean, you go get logos and you get sticky notes and you get letterhead and all of that now has to go
away.
Out the door. All of it away.
Or if you're the first to get it, but then somebody else comes along and they have a very similar product or service and they start using it and now they're stealing off the goodwill and the client base, customer base that you've developed. And if you don't have a registered trademark, there are, what we call common law trademark claims. You still do have some rights, but you have a lot more leverage if you actually have a registered trademark to stop them from doing it.
I will say that I think a lot of people hear the words common law. They go,
Right.
That sounds great. I'm protected by the law. I would offer common law should be reinterpreted as expensive.
Right.
Very, very expensive.
Right.
Because you're going to have to go to a court. You're going to have a lengthy judicial process.
It's not as cut and dry.
No, not at all. So an ounce of prevention is worth a pound of preventing.
Right. And before,
long-term
you embark on a, particular name or logo, it's worth it to search and see if somebody else has thought of it before. Unfortunately, chances are they have. But, I know it's an expense that maybe somebody who's new to business doesn't want to incur, but it's
be much more expensive.
It'll be much more expensive if.
So what is the process of going about getting a trademark?
So first you get what we call a knockout search, and that's a very thorough search of the U.S. Patent Trademark Office's database of registered and filed trademarks. That's if you would just search there typically. If you're only looking to sell in the U.S., you may have to search similar databases in other countries if this is going to be an international good or service. And then you would do a search of the internet for website domains and social media handles and all of this and evaluate whether you have a sufficiently distinctive mark. A sufficiently distinctive mark is something that's not generic or descriptive. For example, if I had a athletic shoe company, if I called it the athletic shoe company, I probably wouldn't be able to
Don't
claim
think
that
that's
as my
unique
own.
enough, huh?
It's literally what it is. It's what's called generic and descriptive. If I called it the Purple Elephant Tin Cup Company, well,
Right.
that's
We live in the land.
Yes.
I always learned in law school way back when my hair wasn't gray that we live in the city with one of the greatest marks. That man just invented a name out of nonsense. Kodak.
Oh, well, what
Just
about Xerox?
Xerox. We just kind of fabricated a name, and those names became synonymous with the product, not that the product drove the name.
For both names, by the way, and apparently this is a good name for. I don't know much about marketing psychology, but having the same letter at the beginning and end and 2 syllables, I guess, is quite optimal, which is why Kodak chose Kodak and Xerox chose Xerox. Fun fact.
The name and the brand, and from my perspective, I think working with business clients over the years, they might think that when you file to get your corporation or your LLC, that you've protected that name.
Right. Or the fact that the state allowed it was the state's
allowed
blessing.
it is sufficient. Or if you went and got
Rookie
a
mistake.
county DBA,
Yes.
that was sufficient. Only
Right.
to find out later a very, very, very expensive. No, that is not sufficient.
That's not the case.
You have a different problem, but you have to go through the process. So you go through your knockout search, you do all of those things, and then about how long does that process take?
That shouldn't take too long with the technology that we currently have. Once it's determined that this is a viable mark, then you fill out the application with the United States Patent and Trademark Office, the PTO, and you submit what they call specimens, showing what your mark is, how you use it in commerce, and then it goes before an examining attorney, and keep your fingers crossed. The examining attorney may have questions, may want additional evidence, and you go through that process. It can take up to a year, start to finish.
Okay. So it's a lengthy process. What do clients do in the interim while they've filed for the mark? Can they use the mark, or what should they be doing?
They can use the mark, and at least it's filed. But once it's filed, there's a period of time where it's published, and others can come and fight you. So if you work with your attorney and they say, well, there are similar marks, but we don't think it's confusingly similar, we think we can get it through. Somebody else might come along and say, no, I have a mark. And then you fight that out at the PTO office. Or somebody else does have that mark. They started using it before you, but they haven't filed. That's another fight. And the fact that you filed first is actually very helpful. So even though you're waiting for a year, the act of filing does afford you some protection. So there's, it's an interesting process. A number of things can happen. But at the end of the day, it's good to know whether you can use the mark or not. So even if you fail in your trademark application, ultimately it's probably a good thing sooner than later.
I would offer too, I think clients see that upfront expense and don't value what it's bought them.
Right.
It's the mark to be able to use it. You do have an expense to maintain it. But if you have maintained that mark and you build a brand around it,
and you use that mark and you police that mark, if you're aware of others trying to use the mark, you have to tell them to stop. If you know about it and do nothing, that could hurt you.
But the brand itself at that point has value assigned to it. And because of that value in a future sale, when you go to have your own succession plan, when you try to exit your business, strong trademark is a huge asset that can be sold. So you will typically recoup all of that value that you've built over the years. So for all those clients out there who are wondering, can I afford to have this? I think it's a question of, can I afford not to?
Ding, ding, ding.
Well, I don't want to eat up too much of our time today,
Yes.
though, Beth. We wanted to make sure that we got out there the winners of our contest. We appreciate all the participants. Please get us names of those dogs. And as always, like,
share, subscribe, share with a friend, share with an enemy, share with all. We appreciate the support.
we're off to do double billing.
Yes.